Your rent just jumped, and you've got 10 days to decide if you're staying or leaving. Sound familiar? If you're renting in South Carolina right now, you might feel like the ground is shifting under your feet. And you're right. South Carolina tenants are getting blindsided right now because the rental laws are changing faster than anyone expected. It feels like overnight, the rule book was rewritten. Between early 2025 and 2026, the state passed a suite of new rules that flipped everything upside down. Now, I'm not going to sugarcoat this. Some of these changes are actually designed to help you, but many of them are quietly making life much harder for renters. The playing field is tilting, and here is the brutal truth. Your landlord knows these rules. They've likely already consulted their attorneys. You need to know them too. In this video, we are going to break down exactly what changed, what it means for your wallet, and most importantly, what you can actually do about it. We're covering the 90-day trap, the new eviction fast track, the truth about that rent cap you heard about, and why a simple piece of paper could save you thousands of dollars. Stick with me for the next 15 minutes. This is information you cannot afford to miss. Let's start with the one everyone is talking about. Number 1, the 90-day notice rule. Now this sounds boring, but it is the number one reason tenants are losing their leverage right now. Back in 2024, the rules were vague. If your landlord wanted to raise the rent or end your lease, they often gave you a standard 30 or 60-day notice. It was stressful, but it was manageable. But as of 07/15/2025, South Carolina enacted the South Carolina Rent Control Act. Under this new law, for any tenancy other than week to week, landlords must give you 90 days written notice before increasing your rent. On the surface, this sounds like a win, right? You get an extra 3 months to plan, you have more time to save money or search for new housing. But here's the catch, and this is where it gets sneaky. Landlords figured out the loophole fast. Many landlords are now sending these 90-day notices exactly 3 months before your lease expires to force your hand early. They are banking on you missing the deadline. Here is the danger zone. If the notice says, "We intend to raise rent or terminate unless you respond," and you don't respond within that window, many leases now automatically assume you are vacating. So you think you have time, but actually, you've already been pushed out. My advice to you, keep every single piece of paper your landlord sends you. Don't just text them. Look for the written notice. That written proof is your only defense in court. If they sent it late, or if they didn't give you the full 90 days, that letter is your shield. Number 2, hits your bank account directly, security deposits. South Carolina is one of the few states in the country with absolutely no maximum limit on what a landlord can charge for a security deposit. As of January 2026, that hasn't changed. They can ask for 2 months, 3 months, whatever the market will bear. However, the return rules have gotten stricter, and landlords are getting smarter about keeping your money. Under SC Code Section 274410, landlords still have 30 days to return your money after you move out. But here's the new 2026 danger I'm seeing. Landlords are increasingly using what they call standard deduction sheets. This is a pre-made list of cleaning costs they deduct from everyone. Is it legal? Only if they follow the rules. The law says if they use different standards for different tenants, they must post these standards openly in the lease or in the office. If they don't post it and they keep your money based on a secret list, you have them. You can sue for 3 times the amount wrongfully withheld, but here is the practical tip. When you move in, take photos. When you move out, take photos. Don't rely on their standard deduction sheet. If they charge you for a dirty oven, but you have a time-stamped photo of a spotless oven, that standard deduction sheet becomes evidence in your favor, not theirs. Number 3 is the big one everyone argues about at the dinner table. Rent increase limits. You might have heard rumors about a rent cap. It's true. Unlike Florida, which effectively banned rent control, South Carolina actually passed a version of it. As of late 2025, generally speaking, a landlord cannot raise your rent by more than 7% plus the Consumer Price Index, or CPI, in a 12-month period. Let's do the math. Let's say the CPI is sitting at 3%. Add the 7% cap, your total limit is a 10% increase. If your rent is $1,500, they can only raise it to $16,050. That's a lot, but it's predictable. This is huge for stability. But, and I need you to listen closely, there is a massive exemption. If your building was built in the last 15 years, this cap does not apply to you. That's right. If you are in a new build, your landlord can still jack your rent up 20%, 30%, even 50% if the market allows it. The logic from the lawmakers was that this encourages new construction, but for you, the tenant, it means you need to check the age of your building before you sign that lease renewal. Number 4, deals with your health. In January 2025, the state passed the Healthy Rental Housing Act, specifically Bill 3232. This addresses the mold issue that plagues so many humid climates in the South. Here is the scenario. You find mold. It's affecting your breathing. Under this new law, if mold materially affects your health, the landlord can actually force you to move out temporarily for repairs. Now, the good news, they must provide a comparable unit or a hotel at no cost to you. That's a win. But here is the bad news that catches people off guard. You still have to pay your full rent while living in that hotel. You don't get a rent-free month just because you had to move. And if you refuse to move for the repairs, they can evict you in days for non-compliance. It's a double-edged sword. You get a safe place to stay, but you lose the comfort of your home, and you have to follow their timeline. Number 5 is the scariest change on the books, and I want you to pay attention to the date. On 03/25/2025, South Carolina introduced Bill 3387. This is the expedited removal law. It allows landlords to bypass the traditional lengthy eviction process if they claim you are an unlawful occupant. Traditionally, eviction takes weeks. You get a hearing, you get to tell your side. Under Bill 3387, by filing a verified petition, a landlord can get an ex parte order. That means a judge signs it without you even being there to defend yourself. The sheriff can then remove you immediately. Here is the trap. Landlords are using this against tenants whose leases have simply expired. They are calling you unauthorized or unlawful occupants to skip the standard 10-day court waiting period. If your lease is up and you're on month-to-month basis, make sure you have written confirmation of your status. If they file this petition, you could come home to locked doors before you even know a case was filed. Number 6 involves a shocking change from January 2025. Bill 3229 sought to stop landlords from requiring credit scores as a condition for a lease. On paper, this is fantastic. It was designed to help low-income renters who have been historically blocked from housing, but the market adjusts, and usually not in your favor. Because landlords can't rely on credit scores to assess risk, many are now asking for 4 to 5 months of rent up front instead to offset the risk. So while the law removed one barrier, it built a massive financial wall in front of another. If you don't have the credit, you now need a massive amount of cash on hand. Number 7 is about protecting yourself before you even move in. Following the coastal flooding trends, as of 2025, South Carolina landlords must disclose visible evidence of mold and flood risks at move-in. This is critical. If they say there's no mold and you find some, you have exactly 5 days to object in writing. Not 5 days to call them, 5 days to send a written objection. If you miss that window, the law assumes the apartment was perfect. You lose your right to sue later for health issues related to that mold. Do not sign that move-in inspection sheet without checking the corners of the bathroom and the windowsills. Finally, number 8. Breaking a lease early. Life happens. You get a job transfer or a family emergency. In South Carolina, you are generally liable for the entire remaining balance of the lease. The landlord has a duty to mitigate, meaning they must try to re-rent the place. But in 2026, landlords are charging marketing fees of $500 to $1,000 to even start looking for a new tenant. They deduct this from your deposit or bill you. It's a new cost to leaving early that didn't exist before. South Carolina rental laws are changing fast. While some caps exist to protect you, the eviction process is speeding up and the financial traps are getting more sophisticated. Your landlord knows these rules because they benefit the property owner. Now you know them too. If this video helped you understand the new landscape, hit that like button. It helps get this information to other South Carolina renters, and make sure you subscribe. Laws change every year, and I break down exactly what it means for you. I want to hear from you. Drop a comment with your South Carolina rental horror story. Have you seen these new standard deduction sheets? Have you received a 90-day notice? Let's talk about it. Knowledge is power. Thanks for watching.